Merci beaucoup, Taylor. Ladies and gentlemen, dear colleagues, once again, it is an honor to be among you today here in Rabat. Although I speak in English, I have decided to make a presentation to you in French and Arabic. I hope you will find it interesting. It's a handmade presentation. Since the country I come from is a typical European state founded on common values which are promoted by the Council of Europe and the European Union, Croatia may serve as a good example of how Europe deals with social justice issues. Accordingly, I would like to begin by saying just a few words about my country. It arose from Tito's communist Yugoslavia, within which Croatia was one of 6 federal units. The dissolution of the former Yugoslavia began in 1990, and it was followed by an extremely cruel war where Croatia fought heavily for its territory and its independence, which it gained in 1991, although the war ended only 4 years later. Croatia is partly a Mediterranean state, bordering on the Adriatic Sea, and its main features are presented on the screen. Until 2000, we had a presidential system of government, and today Croatia has the main features of a parliamentary democracy. And although Croatia is mostly a Catholic country, we are very proud to celebrate this year the 100th anniversary of the recognition of Islam as official religion in Croatia. The Constitutional Judiciary was introduced in 1964 during Tito's Yugoslavia. The Croatian Constitutional Court is today a very, very powerful body. Since 1991, it has been organized along the lines of what is known as the Kelsen, or the European continental model of constitutional review. Accordingly, the court may repeal laws enacted by the Croatian parliament, as well as regulations passed by the executive branch of power and public administration, if it finds them unconstitutional. Croatia has also recognized the Institute of Constitutional Complaint, Amparo, complaint in Spain. The Constitutional Court may quash judgments of the courts if it finds that they have violated individual rights. The principle of social justice is embodied in the Croatian Constitution. As you can see, social justice is promulgated in Croatia as the highest value of the constitutional order and the ground for the interpretation of the Constitution. Moreover, in the first article, Croatia is defined as a social state. A Bill of Rights included in the Constitution contains an extensive list of social rights of the individual. Thus, the Croatian Constitution belongs to the group of so-called socially conscious constitutions. This means that Croatia has accepted the common European constitutional heritage, where a social state is considered as one of the cornerstones of European identity. Jean-Marc Sauvé, Vice President of the French Council of State, gave an illustrative description of what this European heritage means. He stated that Europe has its sign and its tradition, which Europeans must defend. This is European humanism, based on the idea of the rights and human dignity of the person, individual, and on the idea of the obligations and rights of the community. Indeed, Europeans share a deep, common, two-sided conception of the person's human dignity and public interest on the other hand. Sauvé further stated that the experiences gained by the European continent through two totalitarian regimes in the 20th century give it the pressing obligation to defend this European tradition, which has a pronounced legal dimension. So the question is, what is the most important legal means to defend this European tradition? The answer is the constant balancing of these two ideas with the aim to bring them in balance, in harmony. The main legal principle for achieving this balance is the principle of proportionality. The Croatian Constitution expressly recognizes this principle. You can see it on the screen, together with the primary obligations of the courts, which derive from this principle. I am not going to speak today about how government contributes to social justice as a component of the social state. Instead, I would like to show how European constitutional courts deal with it. Namely, the notion of social state and the principle of social justice hinge on the following problem on constitutional judiciary or justice. Namely, how to determine the borderline at which the constitutionalization of social rights clashes with democracy. The standards for determining that borderline, formulated by the German Federal Constitutional Court, are today considered the ruling guidelines for the jurisprudence of other European constitutional courts. So the German court first pointed out that the notion of the social state places obligations before the state, but without giving details as to how they should be fulfilled. Further, constitutional norms which recognize many different social rights are not self-executing and cannot be applied directly. For them to be applied, they must first be elaborated in a law, and very often they must be further specified in subordinate legislation. In other words, the key is in the hands of Parliament. The Constitution has left it to the legislator to elaborate the social domain of the state and to regulate in detail constitutionally guaranteed social rights by, of course, its laws. Consequently, on issues concerning social policies, Parliament has a wide margin of appreciation, that is, a large domain of decision-making based on free political will. Were it otherwise, the notion of the social state would contradict the principle of democracy. This means that the democratic order of a free political decision-making process would be fundamentally restricted and deprived of its essence if Parliament, in which political will is formulated, is obliged by the Constitution itself to accept only one solution in regulating a particular social issue. The two main consequences which are relevant for the constitutional justice or constitutional court jurisdiction derive from this German legal concept, widely accepted in Europe. The first one is related to the protection of individual rights guaranteed by the Constitution. The notion social state and the principle of social justice cannot directly impose boundaries or restrictions on fundamental rights. This means that no one is authorized to justify interference with fundamental rights by referring only and directly to the notion of social state or the principle of social justice, regardless of whether the legislator has permitted the restriction by law and how the legislator has specified this permitted restriction. The second consequence relates to the control of the constitutionality of laws passed by the Parliament. Namely, this external borderline is the ultimate line up to which constitutional courts may control the laws from the aspect of the social state and the social justice. It means that the Constitutional Court may not take on the role of legislative power, and it may not judge whether it would have been better or more appropriate if Parliament had chosen and accepted some other solution instead of the ones they did, provided the accepted solutions do not override this external border of the constitutional frame. Constitutional Court's review of social policy issues or measures is always based on a few components. First, every state intervention in socioeconomic matters must be prescribed by law and must not be discriminatory. Furthermore, the legislature's judgment as to what is necessary in a democratic society to achieve the objectives of social policies in securing social justice and public benefit must not be without an objective and reasonable foundation. That is, the measure employed must not be manifestly disproportionate to the legitimate aid pursued and must not impose an excessive burden of the individual. To conclude, dear colleagues, constitutional courts in Europe must not engage in political regulation, but in legal discernment using legal methods. Constitutional courts must always base their findings exclusively on constitutional norms and not of what might be politically, socially, or economically appropriate. Regarding values such as the social state or social justice, which have a prominent political dimension and which may cause great social turbulence, I consider that the main role of the constitutional courts in Europe in this field is to determine functional guidelines and binding constitutional standards for legislative, administrative, and judicial decision-making. By building a constitutional framework within which policy may be developed, The Constitutional Court is actually the ultimate censor of the reasonableness and non-arbitrariness of governmental actions. More on these viewpoints, dear friend, can be found in the decision of the Croatian Constitutional Court, which is available to you in English. Esteemed colleagues, I came to this great country to introduce to you the role of constitutional justice in protecting and promoting social justice in Europe. I hope that I have given you a general idea of what we are and what we do. Thank you very much for your hospitality and thank you for your attention. Shukran.